Good morning, I'm Gary DeWaal, and this is Bridging the Week for March 19th to 23rd, and today is March 26, 2018. The Department of Justice and the Securities and Exchange Commission opposed a motion to dismiss previously filed by a defendant named in a criminal indictment charging him with offering and selling two types of digital tokens issued in initial coin offerings that the Department of Justice claimed were securities without required registration. The defendants had argued that the digital tokens, termed cryptocurrencies, were not securities because they were currencies and in any case were not investment contracts as charged under applicable law. Separately, over 95 commentators weighed in on proposed guidance by the Commodity Futures Trading Commission as to what constitutes actual delivery of a virtual currency to a retail client in a leveraged or financed transaction. This is the first week of the baseball season, so I can once again be tormented by another disappointing season by the New York Mets. Let's get started. The Department of Justice opposed the February 27th motion of Maxim Zasalevsky to dismiss the criminal indictment that had been filed against him in November 2017, charging that he engaged in illegal unregistered security offerings and securities fraud in connection with the initial coin offerings of two digital tokens, REcoin and DRC, organized by two of his companies, REcoin Group Foundation LLC and DRC World Inc. The complaint was filed in a federal court in Brooklyn, New York. The Securities and Exchange Commission supported the Department of Justice opposition motion. Among other things, Mr. Zasalevsky claimed in his motion that the digital tokens he tried to create were not securities but cryptocurrencies, and that all currencies, fiat and otherwise, are not securities under applicable law. The DOJ argued that the REcoin and DRC ICOs were securities because they were prototypical investment contracts. According to the DOJ, applying the landmark Supreme Court decision in SEC v. W.J. Howie Company, each ICO was an investment contract because it represented, quote, an investment of money in a common enterprise with a reasonable expectation of profits to be derived solely from the entrepreneurial or managerial efforts of others, end of quote. According to the DOJ, it was irrelevant that no dividends were to be paid to investors. Rather, both REcoin and DRC tokens were sold as investments that would increase in value because of the managerial efforts of Mr. Zasalevsky. And this potential appreciation would be equivalent to prorated distribution, satisfying the Howie requirement that investors expect profits as a result of their investment. Although the DOJ conceded that currencies are excluded from the definition of currencies, DOJ said that REcoin and DRC tokens were not currencies solely because they were marketed as cryptocurrencies. Indeed, observed the DOJ, quote, the superficial resemblance in its label is the only similarity between REcoin, DRC, and currency, end of quote. In its view, currencies under applicable law are only legal tender or something equivalent, quote, like a cash substitute, end of quote. The Commodity Futures Trading Commission received over 95 comments in response to its December 20th, 2017 request for comment to a proposed interpretation requiring actual delivery of a virtual currency to a retail client within 28 days to avoid commission registration requirements by persons selling and either financing or arranging finance of the virtual currency. In response to a CFTC query as to whether 28 days or a shorter period should be the applicable time period, FIA recommended that the Commission should, quote, allow the virtual currency markets to continue to develop, end of quote, before assessing whether a shorter period is appropriate. Alternatively, the National Futures Association indicated that a shorter period is likely prudent because virtual currencies, quote, are offered primarily for speculative investment purposes, are extremely volatile, and have attracted a large number of retail participants, end of quote. Gemini Trust Company, which operates a virtual commodity exchange, likewise argued that a 28-day delivery window is quote, unnecessarily long does not reflect market practices and may give rise to fraudulent activity, end of quote. Coinbase, which also operates a virtual currency exchange, challenged CFTC suggestions that only virtual currency transactions consummated on a public blockchain should constitute actual delivery. Coinbase observed that such a view, quote, fails to recognize limitations on the capacity of the public ledger, end of quote. The firm also indicated that the CFTC suggestion that wallet holders have, quote, unfettered access to digital assets in those wallets, end of quote, may compromise anti-money laundering and economic sanction controls and, quote-unquote, unnecessarily expose digital assets to cyber theft. The Chamber of Digital Commerce took a different view, however, saying that a purchaser should only be deemed to have full control when a seller or offer exchange delivers the entire quantity of virtual currency to a purchaser's wallet or its depository warehouse wallet, quote, away from the, end of quote, the offerer or offerer's platform. However, the Chamber argued that the Commission, quote, should not require that a purchaser hold a private key for a depository wallet so long as the purchaser has access and the ability to move the virtual currency from the depository without restriction by the seller or offerer, end of quote. FIA challenged the CFTC's assessment that for actual delivery to occur, there must be no liens by an offerer, counterparty seller, or other person acting in concert with the offerer seller, resulting from the use of margin, leverage, or financing. FIA argued that the issue of liens, quote, is not relevant, end of quote, and that the granting of liens is common practice in the cash, commodity, and retail markets, for example, order loans. Coinbase, however, said that for actual delivery to occur, quote, the finance or margin provider should not hold any lien on the digital assets or be able to otherwise restrict transfer resulting from the provision of financing or leverage, end of quote. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great, and until the next edition of Bridging the Week, play ball.